For thousands of immigrants living in the United States, a green card represents the end of temporary visas, constant renewals, and uncertainty. It means finally building a permanent life in America. For years, the system offered a clear path. Eligible applicants could use a process called adjustment of status, allowing them to file their paperwork and complete their immigration journey without ever leaving their U.S. homes. This internal pathway was incredibly protective. Even if someone arrived on a temporary tourist or student visa and stayed long past their authorized time, they could often still adjust their status from within the country if they later married a U.S. citizen. That protection is vanishing. A newly surfaced policy memo from U.S. Citizenship and Immigration Services is abruptly rewriting these long-standing rules. Immigration attorneys like Max Fuchs are warning that this shift introduces a massive legal hurdle for people trying to become permanent residents. The standard logic seems simple. If you can't finish your paperwork inside the United States, you leave the country and finish it at a consulate abroad. But doing exactly that could now permanently lock you out. Thousands of current applicants are completely unaware of this vulnerability. They are moving forward with their cases, assuming the old rules still apply. Simply cooperating with new government instructions to attend an interview overseas could accidentally trigger a devastating 10-year exile from America. Under the new guidance, vulnerable applicants face a strict requirement to stay in the U.S. They have to prove extraordinary circumstances prevented them from returning to their home country for consular processing. Ordinary inconvenience won't pass the test. Applicants must show severe medical conditions, proof that they are the sole caregiver for a U.S. citizen, or that an American employer would face severe hardship without their services. This H-1B classification is key. For dual intent visa holders, like intra-company transferees or specialized professionals, the immigration system already recognizes they might pursue permanent residency, giving them built-in legal protections against this new filter. But for those holding this F1 classification for non-immigrant student status, or those on tourist visas, no such protection exists. These visitors who overstayed their initial authorized time are the primary targets of this change. This sudden policy acts as an aggressive legal filter, stripping away internal protections for temporary overstays and forcing them directly toward the border. When an applicant fails that extraordinary circumstances test, it sets off a specific chain of events. First, the government denies the internal adjustment of status. The applicant is then formally instructed to return to their home country to finish the process at a U.S. consulate. Assuming everything is proceeding normally, the applicant complies. They book a flight and physically leave the United States for their interview. This triggers a consequence buried in the legal code. Remaining in the country for more than 1 year after a visa expires creates a dormant legal penalty. The exact moment the applicant crosses the border to comply with the exit instruction, that dormant penalty automatically detonates. The government's own instruction to leave the country provides the very trigger needed to lock the applicant out. By attempting to follow the law and attend an interview abroad, the applicant unknowingly guarantees they cannot return for a decade. This shift relies on the harsh geographic reality of U.S. immigration enforcement. Deporting someone who is actively fighting their case inside the United States requires a lengthy, difficult legal process. But at the border, agents can effortlessly deny entry to outsiders with absolute, immediate authority. Following instructions and attending a foreign interview used to be standard procedure. Now it is a high-stakes gamble with your future. Immigration attorneys are urging extreme caution. You should never book international travel or respond to an exit instruction without securing professional legal counsel first. In this new environment, relying on internet rumors or assumptions instead of an attorney could cost you 10 years of your life.